very large for this session. I'm Janet Grant, Chair of Fair Districts Georgia, and pleased to have you all with us tonight. And we are in for a treat. We've got a wonderful panel assembled to speak to some really relevant, timely issues in redistricting. So welcome. As is our tradition, as we kind of get going here with a few housekeeping items and wait for a few other folks to join us. Please tell us where you're joining us from. We're always interested to see what the poll is of our sessions, and so we'd love to see who's with us. Let me get my chat up so I can see. So go into chat and let us know who's here. We've got someone, Ken from Alpharetta. Athens, great. Statesboro, great. Statesboro is an example we use all the time for some gerrymandering issues. UGA in Athens, great. We've got some UGA alum on our panel today. Augusta, Brunswick, wow, we're really pulling from across the state. San Diego, I'm not sure that there's a San Diego, Georgia. I wonder if that's San Diego, California. Pulling from folks even across the country. So, well, welcome and thank you for joining us today. Just a few logistics I'm going to go into, and then we're going to get right to our panel. And we are recording this session. You should have gotten a note, I guess, that there was recording going on, and that's because we really want to make this available to even a wider audience than was able to join us tonight. So I hope you're fine with that. You will find all of our town hall meeting recordings on our website, as well as all of the slide decks that are used. So we wanted to make those available to everybody. Through the panel discussion that we're going to be launching into here in a minute, we'd like for you to be thinking about your questions and putting those in the chat. And we will, after the panel discussion, we have allocated quite a bit of time for Q&A with the questions coming from all of you. So please use the chat function in order to give us a heads up on your questions as we get closer to that time. So I want to introduce our moderator for tonight, and then he'll introduce our speakers. Al Pearson is serving as our moderator tonight, and Al is a member of the board of Fair Districts Georgia. And Al comes to us with a lot of interest and background in this subject. Al is an attorney. He graduated with a BA in history. I learned some things about Al in putting this together. He has a BA in history from Birmingham Southern College. He has a JD from Vanderbilt School of Law. And the one thing I learned about Al today in putting this together is that he actually served as Supreme Court fellow for Chief Rehnquist, as well as Justice Powell. He also was a professor of law at the University of Georgia, as well as practicing law. And the last decade or so has really been focused on voting rights and redistricting. So with that, we thought we would pull from the best expert we have on our board to moderate this phenomenal panel tonight. So Al, take it away.
All right. Well, I'd like to welcome everybody to the program. As many of you know, probably all of you know, that we're at a fairly critical point in voting rights litigation under the Voting Rights Act, and there are a number of cases that are pending in the South, in Alabama and Georgia, which we'll focus on today. And our brain trust, our panelists, will talk a little bit about the cases that are known as Section 2 of the Voting Rights Act litigation, which are cases that are back down in the lower courts at the trial court level in Alabama and in Georgia, following the Supreme Court's decision in Allen versus Milligan. And so our brain trust, our panel, will be talking about what's going on in Alabama and then in Georgia, because their cases have some similarities. And then we'll, after each of them makes a short presentation, just kind of outlining some issues that we've discussed before getting started, that they'll kind of give you a preview of some points And after each of their presentations, we'll go into a panel discussion where we'll go into a few more details about these cases and some insights from them about what might happen in these cases and where the Supreme Court might be persuaded to go, if not in the short term, perhaps in the longer term. And so at this point, I'm going to just turn it over to our panelists. I'll introduce each of them, and then we'll let them make their short presentations. Okay, for first on the panel is Kareem Crayton. He is with the Brennan Center. He's the Senior Director for Voting and Representation, and he manages the Brennan Center's efforts to implement voter reforms, to fight voter suppression and intimidation, and also to fight back and push and resist redistricting abuses. Kareem is a native of Montgomery, Alabama, not far from my hometown. He's a magna cum laude graduate of Harvard College. And then after that, not having enough education at Harvard, he gets a PhD in political science and then a law degree from Stanford. So this gentleman here is well-trained and well-experienced. And Kareem, so glad to have you on our panel. Next is Amy Steigerwalt. And Amy is a professor and chair of the political science department at Georgia State University. And she comes to us having received a BA from Emory University and her PhD from University of California. And Amy, we're delighted to have you here to sort of keep the lawyers at bay. Sometimes we need to be controlled. And then the third panelist is Rahul Garabadu, and Rahul is a Georgia native, and he is the voting rights staff attorney at the ACLU of Georgia, and he has been involved in voting rights litigation in Georgia and is one of the attorneys that's involved in the case that is currently pending before Judge Steve Jones, in the Northern District of Georgia in the Alpha Phi Alpha versus Raffensperger case. Now, there are three variations of cases that are pending in Judge Jones' court. And Rahul has got his JD from Harvard, and he received a BA in economics from Georgetown University. And Rahul, thank you again for participating, and we appreciate your willingness to take advantage of this time to tell us a little bit about what may be happening in the Northern District of Georgia shortly, because I think we're going to be starting a hearing. Is it on September 5th? So that's going to get going. The Alabama case has already been going on a little bit, and Kareem has been following that. So at this point, I'm going to turn the program over to the panelists, and I'm going to start with Kareem and then go to Rahul, and then Amy, you're trying to be the utility infielder to sort of round things up and put some context on it from a broad perspective. So Kareem, talk a little bit about the Alabama case, how I got there, how I got back, and if you got enough time within 5 minutes to talk about the Alabama litigation strategy that seems to be drawn from the George Wallace days, you know, go to hell, Washington. But tell us about that, if you would.
Sure, and thank you, Alan, Fair District, Georgia, for inviting us all, but in particular me, since I'm talking to participate. I think it's a really important time. I'll try to use these 5 minutes efficiently as best I can. And if I have really a lot of time over, I'll give you the prospects for the Crimson Tide this season. Doubtful, but we'll try. So here's what I can say about the, I think as a broad matter, we should probably start by talking about sort of the law at issue, and that will help us understand, I think, both for the Alabama case and the Georgia case, sort of what people are really sort of fighting about. So if I'm talking about redistricting, there are a lot of different tools of the trade that people need to know about. But one of them that's really the most common comes from the Voting Rights Act, which I assume most of you all know generally about. It contains different provisions, but the one that has been actually now, especially the most sort of useful tool throughout the country has been this provision called Section 2 of the Voting Rights Act. And it's essentially a tool that allows litigants to go into court and challenge in the redistricting case maps that unduly pack or oversaturate districts with large numbers of people of color or crack unduly divide them in ways that would interfere with the sort of fair allocation of voting power. We'll get into what that means in a minute. But generally speaking, and this is now synthesizing a bunch of law, most people go in to establish that they've met this particular test that the Supreme Court developed in 1986. It's known as the Jingles test, and it essentially boils down to three different evidentiary showings that a plaintiff needs to show in order to say, hey, you've actually drawn these districts in a way that interferes with what the law describes as the ability of a plaintiff's class, in this case, a group of people of color, to exercise their right to vote in a way that allows them to have an equal opportunity to elect candidates of choice. And that's usually a phrase that you hear a lot. But the first thing you need to show is that the group that's bringing the claim is large enough and geographically compact enough to have a district that represents their interests. And in the court's parlance, that is meant to be a majority of the elected district. So 50% or more of the voting age population is usually what's required. Assuming you can do that, then the second part of the test is to show that the group bringing the claim is politically cohesive, that it's not just any group of people who happen to, be in the same space, but they're people who actually understand their identity, whether it's cultural, social, over a large number of factors, that they understand themselves to be a part of a group that wants generally some of the same things from politics. And then the third, and this is often also crucial, that given those first two, that they operate in a space when they choose candidates for office, that they usually are candidates who lose because of what we call racially polarized voting. And that's essentially a fancy way of saying that white voters generally vote as a group to oppose the elected people or the chosen candidates of the minority group, the plaintiff's class that's bringing the claim. I'm now in Alabama going to refer to that group usually almost always as Black voters, but it can apply to most any group that can satisfy the factors in the Jingles test. And essentially, if the court finds that those three factors have met, they do an analysis and determine whether or not the state should draw a new set of districts that more properly reflect Black voters' interests. And now to talk about Milligan in the few minutes I have left, it might be useful to show the map of the state of Alabama as I describe it. In 2022, or following the census in 2020, the state of Alabama sat down to draw 7 congressional districts, the same number as it had before. The difference this time was that African Americans in the state of Alabama were about 27% of the population. Now, as it turns out, it was possible numerically to craft 2 districts in which African Americans were a majority of the population. That's just a math point. I'll get to the law in a minute. But what you see on the left is what the state of Alabama drew, which is 1 majority Black district, the same number of districts that were African American majority prior to 2022. And it is also the only district in which the elections produced a Democrat. It's consistently been Democratic, but as I said, the population of African Americans in Alabama is large enough to have created 2. This point was brought up to Alabama. I'll just give you full disclosure. In a prior job, I was actually advising some of the minority party in this because there were real questions about how the law would be applied. We made the argument to the state legislature that the law actually would encourage you to create 2 districts. The state would not do it. This goes to the Supreme Court. The Supreme Court says, actually, we agree, surprising a lot of people, because this is not a court that would say, in most cases, they're like champions of the Voting Rights Act. But in this case, the court said, actually, this looks like a textbook case of where Section 2 would apply. Because, again, I said, there are enough African Americans to create a second majority Black district. It's very clear from the history of the state of Alabama that African Americans see themselves as a politically cohesive group, as it's been expressed in prior votes. But most important, that there's racially polarized voting such that outside of District 7, you never have the opportunity, either in congressional districts or statewide elections, to elect Black preferred candidates. That's usually Democratic candidates, but almost always across the board, the majority of white voters vote against preferred candidates that the majority of Black voters want. Under Section 2, that's exactly the place where you should have a second majority Black districts. And what you see on the right is what the plaintiffs have proposed as a possible answer to this, which essentially takes some part of the original District 7 and adds to it a second majority Black district, which is in pink, District 2, that basically puts the lower part and the eastern part of the Black Belt into a district that is also majority Black. And the argument that they've made is, look, it's possible to draw this district. The district looks like pretty much most other districts that the state itself has drawn in the past. In fact, District 7 takes the basic contours that the state has offered and craft a second majority Black district. Now, the state has now been ordered by the local district court to redraw the maps. I'm going to fast forward briefly to tell you they refused to draw a second majority Black district. And this week, the local district court has asked the state to explain itself. And their answer to this has basically been, and I'll stop here, this idea about communities of interest. What you'll see in the lower left part, the little tail of Alabama, are two Gulf Coast districts, Mobile and Baldwin counties. And the state of Alabama has made the argument that as the plaintiffs would draw its map, you see District 2 dips a little bit into Mobile County. The city of Mobile has been the second largest city for a very long time, and it has a substantial African-American population. The real question in this case comes simply down to this. Can you draw a district that goes into Mobile to create the second majority Black district? Or, as the state would have it, is there more importance in keeping those two counties together and undivided? That's really the question that's at hand. The district court is working with it going forward. And the state seems to have the view that if they take this case all the way up to the Supreme Court, that's potentially going to give them an opportunity to revisit the question.
Okay, let's get Rahul in here to kind of talk about those issues from the Georgia perspective. I think that's a very good explanation of the concept. So Rahul, do you want to kind of pick up from there and talk about the genesis of the Alabama cases and what you think about the challenge of drawing a good illustrative map in Georgia as compared to Alabama, because you've got a lot more space in Alabama that given they only have 7 districts. We've got 14.
Sure, and thank you so much for having me. And before I get into the weeds, I just wanted to say, there are many redistricting cases going on in Georgia right now. So I represent plaintiffs in a lawsuit called Alpha Phi Alpha versus Raffensperger. We are one of those 5 cases. Our case focuses specifically on state legislative maps, so state House and state Senate maps in Georgia, using Section 2 of the Voting Rights Act, which Kareem has nicely teed up for me to explain this case with. So the heart of our case and the heart of the 3 Section 2 cases that do go to trial on September 5th is that given the tremendous growth in Black voting age population between 2010 and 2020, that the state of Georgia could have and should have drawn more districts in Georgia that allowed Black voters who we're suing on behalf of to elect candidates of their choice. And the state did not do that. And so our case is basically trying to show, like the litigants in Alabama are trying to show, that the state could have drawn a greater number of Black majority districts that allowed Black voters to elect candidates their choice. And so, like I said, our case centers around the state legislative districts. Often in redistricting fights, I think Congress gets a lot of a bandwidth, given how close, the congressional balance of power is right now. But I think what's often lost is the fact that state legislative seats are really, really important too. The Georgia General Assembly makes really, really important decisions about criminal justice reform, education, voting rights, and these issues are really affected by how the legislature draws maps in play. So now might be a good time to take a look at those maps to show the Georgia maps that we have in the slides, Al.
Statewide maps, okay. And then we've got the blow-ups of the Atlanta metro area as well.
Great. So these maps show the congressional district plans. And again, I want to make the disclaimer that I represent plaintiffs who are challenging the state legislative maps, but because we wanted to show y'all maps that everyone could see, because state legislative districts are so small, comparatively speaking, we're using this kind of as an illustrative example. But what you can see here is on the left-hand side, you see the enacted map for the 2022 election. And you see there that the state of Georgia drew 3 Black majority districts centered around the Atlanta area. In one of the other Section 2 cases, however, the illustrative map on the right shows that using the Jingles preconditions, those factors that Kareem talked about, looking at where Black voters live, where Black voter growth has happened in the state of Georgia, you could have easily drawn 4 Black majority districts, again, centered around that Atlanta metro area. And this illustrative plan kind of takes us back a little bit to a little closer to what the 2011 through 2021 maps look like, focusing on the North Metro Atlanta area, carving out another Black majority district there. And so this is again on the congressional side, and these zoomed up maps show you a little bit more about where these districts are being drawn. But the principles are very similar to our state legislative districts. In our state legislative maps, we're litigating in the South Metro Atlanta area, Southwest Georgia, the Augusta area, again, in areas where the state could have drawn additional Black majority maps, but did not, despite the tremendous growth in Black voting age population. So I'll leave it there. I know we'll talk a little bit more about the litigation and how each of these cases kind of interact with each other. But I want to be cognizant of time, so I'll leave it at that.
All right, yeah. Well, Amy, you got the floor. Talk a little bit about any thoughts about the future of Section 2 litigation. In the Allen opinion, there were a number of little side comments that suggested to me that the majority could be somewhat fragile, and the emphasis in the court's opinion on how fact-intensive these cases are makes me think that the court is setting it up so that trial judges can make fact findings on the various Gingles factors or the Senate factors that could easily derail a Section 2 case, depending on the predilections of the judges or the locale. So talk a little bit about that from your perspective.
Great. Well, thank you all so much for having me. I'm really pleased to be here tonight and to be able to join in this discussion. And I think there's a couple of things to keep in mind as we sort of look at these cases of where we are now and also what's sort of coming in the future. One is that we have to also remember that in previously, the court also decided another voting rights case that was called Rucho v. Common Cause. And the reason that this case is really important, and it really ties nicely with the issues we're talking about here and some of the concerns with Section 2 and what might be happening, is that in that case, the court said partisan gerrymandering is a political question. And because it's a political question, we can't hear cases about it in the federal courts. Now, it leaves it open still possibly to the state courts, but at least in the federal perspective, it says we're going to leave aside partisan gerrymandering. Now, partisan gerrymandering is that you draw districts to support your party. So if you are you're Democrats and you're in the majority, that you draw districts so that the Democratic incumbents will win, and you'll try to make it more difficult for incumbents from the Republican Party to win or to possibly gain seats, and vice versa. Now, why is discussion of partisan gerrymandering at all matter when we're talking about race? Well, as Kareem alluded to, one of the things, particularly when it comes to Black voters, and particularly Black voters in the South, is that they are by far the most supportive single demographic of the Democratic Party. In fact, there is a voting alignment between people who identify as Black voters, or voters who identify as Black, and voting for the Democratic Party upwards of about 95%. You also have a pretty strong correlation between those who are white and voting for the Republican Party and voting Republican, but it's not quite as high, right? Of those that are that identify as Republicans, it's incredibly high. You've got sort of a middle group, but you do also have this fact that you've got sort of these very stark racial differences that occur there. One of the questions that the court has brought up a number of times, especially certain justices on the court, and as this may affect going further, is are we really having a discussion when we talk about racial gerrymandering about race or about partisanship? Because if it's a question about partisanship, then the courts can't be involved. If it's a question about race, then they can, at least for the moment. The other side of this, as we sort of think about it going forward, is that, as Al was talking about, one of the things that many of the, especially dissenting justices, alluded to in their decision was suggesting that, number one, it was problematic to bring race into this at all, that sort of the interpretation of Section 2 that was being utilized by the court and sort of being pushed through was sort of elevating race over a lot of other issues and getting rid of and sort of subsuming these other concerns that we might have, such as how compact are the districts, and also what in fact are actual commonalities of interest among groups, and are we trying to, in many ways, elevate the idea of race over something like living in an urban area, living in an industrial area, living in an agricultural area, concerns of being on the coast versus being inland, and so on, right? And so that's sort of especially where that question about the Mobile district comes in, of saying, isn't everyone who lives in Mobile going to possibly be much more alike than those who might live in sort of other areas, especially that are more rural or more agricultural or more industrial. And so going forward, what we have are both this tension between what does it mean in terms of whether we view this as a question of race or a question of partisanship, especially when the courts are involved, right? And especially when we know that there is this high linkage. What does it mean to suggest that a group has common interests and needs political power? And how much of that, how do we determine that, and how does that go forward? And finally, where do the other cases that can also be brought under Section 2 fall into this? Because what we have talked a lot about, right, and we're mostly focusing is on redistricting, but Section 2 also talks about access to voting overall. And so there's a number of pending cases in a lot of states that are about those issues, where again, it's trying to figure out what is the correct determination to be able to use, whether or not, due to race, individuals are being denied the opportunity to vote, as opposed to having their vote diluted by not being able to elect those that they would prefer. And so we've also got sort of other cases there. And again, that the Supreme Court has sort of suggested that it's not sure it feels great about those cases either, and particularly putting that sort of predominance on race. Obviously, this ties to sort of bring it sort of full circle with a lot of the cases that we've seen coming out of the court, having to deal with affirmative action, having to deal with other determinations where they want to sort of back away and say, we need to stop sort of talking about race and instead discuss things in a race neutral manner, because all that's doing is sort of subsuming this discussion. And so what that means is, to some degrees, we're not really sure what's going to happen going forward. Some of it will be dependent upon the cases. Some of it's what allows to come forward. And I also think we're going to have to see how far the court is willing to, on some level, extend Rousseau and use, for sort of lack of a better term, the social scientific data that shows this really high correlation between race and partisan voting, which might allow an argument to say, no, this is really all a discussion of partisanship and partisan gerrymandering, at which point you can't hear these cases at all.
Okay, I have a question. I don't want to spend too much time on this, but I think it's important. In the Alabama case and in the Georgia case, you had at the trial court level 2 detailed opinions at the preliminary injunctive phase where fact findings were made, elaborate analysis was done. Stanley Marcus, the guy who, I guess in the Alabama case, he wrote Larios versus Cox back in 2004, which I was involved in way back then. But what I'm interested in getting you guys to just comment briefly on, what fact findings and legal issues were resolved in the initial hearing? Are they all open for rediscussion, or are some of those fact findings binding on the judge? Is there any collateral estoppel effect or anything like that? Because I'm looking at it, I think, well, you got the remedy phase and then and the injunctive relief phase. And Steve Jones in the Alabama case where he denied the more recent motion for summary judgment, he makes a big deal out of saying, well, there are factual issues that need to be resolved. And so I'm thinking, well, are we back at square one again? And then pertinent to this, Kareem, in the Alabama case, the Livingston map seems like to me it's designed to really challenge the illustrative map by showing the first and the second districts. They're splayed east to west, and the Livingston map makes the districts more compact, and it looks like they're trying to go for compactness and as an issue in the case. So talk a little bit about your thoughts about what's foreclosed, or I mean, maybe the court just may stay with that issue and not redetermine some of the facts that I thought were fairly well developed and the court did. So any carryover effect from the preliminary injunctive?
Yeah, I'll try to be brief about this, but you nicely described exactly what happened in the hearing Monday and Tuesday in the trial court on remedy. The question before really the court and Judge Marcus was like a laser beam right on this very issue. What carries over from the work that we've done on the facts? And you could have taken the state's view that it's a new law, and because it's a new law, it's a new day. And, there was some back and forth about that. But of course, there's also the problem of the law of the case. As you say, you might be a stop from imagining new facts. I would say what I will tell you happened is probably the most practical way of getting to the same point that I think they probably should have anyway, which is Judge Marcus asked that question about, well, okay, so if we made these findings factual, and detailed, would you, he asked the state, would you disagree if the state would you object to the plaintiffs essentially reintroducing that evidence? And the state says, well, I guess not. And this, the plaintiff's position throughout was, well, we can go through the, process of just reintroducing this evidence. But the only thing that really, from their perspective, is different is that the state has changed its maps.
Yeah.
Now, they also argue, the state does, that in addition to passing their map, the point that you made is sort of, I think, what they're hanging a lot of attention on, which is they also passed a series of findings that apparently were known only to a few people, including the lawyers representing the state, that sort of redefine what communities of interest were. And interestingly enough, those communities of interest as newly defined perfectly matched up to the map that the state wanted to adopt. So you can either think that in this new day approach means that the state has an advantage over what the plaintiffs have offered, or as the plaintiffs would offer, well, this looks a little fishy. This is sort of a pretextual way of trying to protect your map. And in many ways, I think one of the judges asked the state, well, wait a minute, if you can do that, basically this is meaning anything you want to pass, you just adopt some explanation, a post hoc explanation to justify it. State didn't really have a good answer to that. But I think the question you raised is really the question at hand. Is on part one of Jingles, is it possible for the state to redefine what a reasonably compact plaintiff's class is?
Kareem, Rahul, what do you think about the carryover effect is that a battle that you anticipate having to fight?
No, not entirely. We're in a little bit of a different posture than Alabama. Alabama's in the remedial phase. We are about to head into trial, so it's a little bit different. For folks on the call, some background, we moved to a preliminary injunction in February of 2022, right after the maps were passed. The maps were passed in December of 2021. We had an emergency hearing in February. We got a 230-page opinion from the court. About 200 pages of that order were about the merits of the case and the judge ultimately concluded that we were likely to succeed on the merits. And then the last 30 pages were how it was too close to an election to implement the relief that we were seeking. So ultimately that injunction was denied on those grounds that it was too close to the election. But we have about 200 pages of kind of the judge's thinking on the likelihood of success. So that gives us a lot to work with that we'll be using at trial. It gives us a good roadmap of, where we need to, show the court exactly what our evidence is. We've amended our maps slightly after since February of 2022, between then and now, to kind of take into account some of the court's findings. And so I don't think we're at a blank page now where we have to start all over again. We do have, we're at a bench trial now. So the judge is going to kind of want us to present a clean trial record so that all the facts are, out there, all the credibility determinations can be made. And one point I want to make is that these Section 2 voting rights cases are very, very fact intensive. And it's what's called a very intensely local appraisal. So it's very important for a judge to make those credibility determinations at trial, because it's a very functional analysis that you have to march through in order to prove your case as plaintiff. So we know kind of what the roadmap looks like based on our PI hearing. We intend to show, each of these elements. We intend to provide that intensely local appraisal in the 2 weeks that we have starting in September. But I think we have a good roadmap to go off of.
Well, let me ask you one question before switching over to Amy. In the congressional map, do you think that the case is made stronger by virtue of the fact that Lizzie McBath's district was cratered and she was shifted over to run in the district? Who's the woman who was in the 7th district from Gwinnett County?
Representative Bordeaux.
Yeah. Do you think the fact that they tampered with McBath's district and basically effectively paired two Democrats is a fact that's going to help you or help the case? Any thoughts on that?
I won't speculate too much on that. Again, I represent
I know just your general thoughts,
are
whether you thought it would
challenging
help or hurt the
state
case.
legislative map. So I'm going to stick to what I know there. But if Kareem or Amy want to take a shot at that, I'll let them do that. But I don't want to comment on a pending case that I'm not a part of.
Well, Amy, we're sort of switching over to you, and one of the things that you said talked earlier about is Ruscio, and that's something that I think is a fairly interesting subject insofar as fact finding is concerned. And let me pose it in this way: suppose in Alabama or in Georgia they say, well, this had nothing to do with race. We're just trying to promote the strength of the Republican Party. So that creates a fact-finding issue. Is that really what your motivation is, or is it really something against black voters? Where on the spectrum are we going with Ruscio being in the hopper now? But I have not seen too many cases lately where where Ruscio is really discussed at great length. And Kareem, you and Rahul may know about that, but Amy, why don't you start us off with that?
Well, I think it is more that it's not being discussed. What it did do was, number one, derail a bunch of cases that were in the process of moving forward, because there were a number of places that were trying to make an argument about, or parties trying to make an argument about that the gerrymandering on a partisan level went so far as to basically make the votes of certain people not in fact, right, be one person, one vote, right? That their vote was basically not as, didn't mean as much because of the way they had drawn those districts and allowing them to be able to see those that they wanted to see elected. And that's where the court said, well, we're not going to get in that because this is a completely, fine thing to be able to use. Now, the flip side of it is that right now, Section 2 of the Voting Rights Act is, in fact, still good law. But what we're seeing from the court, right, and particularly from some of the more conservative justices, is inching towards this argument of saying we shouldn't be looking at race, and also, is it really about race or is it about something else, right? Which sort of leads them on that path of putting it together. And so I think that's one of the things that we're going to have to see how that starts to develop and how it is utilized and where they are going, of how far they want to take this idea of sort of suggesting that any of the analysis being done under Section 2, right, in suggesting that there is sort of a racially motivated dilution of, or actually not motivated. You don't actually have to show an intent to discriminate. You just have to show that there was actually a dilution based upon a cohesive group that is formed by race. Because remember, this is sort of the flip side of it. It's not about vote dilution of any group, even if you can show that they are cohesive and contiguous, et cetera, right? The Voting Rights Act is really focused, Section 2 is focused on it being a group that is also defined by race. And so that's partly also where we're moving to, is this idea of, is that the right group to make? And, right, as we were just discussing, is the correct way to even understand what is a community of interest, as Kareem was alluding to. Is it in fact based on race, or should it be based upon these other factors that in fact are much more important and might drive people's voting decisions more? So that's kind of the debate that's going on sort of in the court and more broadly, and that could possibly affect these cases.
One thing in the Roberts opinion, I hope I'm not misremembering this, but there was a sentence or two in there where Roberts was noting that, a number of Section 2 cases have been litigated over time, and he said something like 18 out of 20 have been lost in the Supreme Court. And I took that to be suggesting or hinting that maybe voting rights cases, Section 2 cases, are going to sort of disappear over time because of population shifts, the fact that the mix of population in a lot of areas has become greater, and therefore reaching the 50% racial threshold may be more difficult. And so I'd like for you to comment about the future of Section 2 litigation, whether Roberts is onto something. And related to this is, are Section 2 cases more localized in the South, or are they populating in other areas of the country to a great extent? So any of you want to start out? Kareem, Rahul, just kind of interested in that issue.
I want to make a couple of observations, partly connected to Amy's points, and then I'd say a word or two about the point that you mentioned now. There are three things that we know to be true about race as it operates in this space. It is impossible to draw lines without some attention to the racial effects of the line that you draw, right? I've done it many times. Among the things that you look at, even when you don't look at it, geographically where people of color happen to live in a state. So you're never getting away from that. So the analogies, as I think many states have tried to make to affirmative action, doesn't really work here. Second, the point about the intertwined nature of race and politics make this in some ways a Gordian knot. I don't know that it is possible to treat any, one of these cases as purely a race case or purely a politics case. There is a case being heard soon this term from South Carolina that raises another claim we haven't yet talked about, racial gerrymandering case that questions whether or not the intention of the legislature was focused on race or focused on party. And, I won't comment beyond that other than to say in South Carolina, much like Alabama, race and party are heavily intertwined. As to the question that, and last, I guess I need to say a word about communities of interest. What is peculiar about the approach that seems to be emerging from the states, a lot of these states in their approach to communities of interest, you can call any number of things communities of interest, but apparently thinking about how race has an influential effect on where you live, what issues concern you, that seems to be off bounds. You can't do it. And that seems really troubling, particularly given the history of marginalizing groups based on race. But put that to the side. To your point, Al, I think it is correct that one of the reasons that the Chief Justice seems okay enough with authoring this decision that essentially affirms 40 years of case law on Section 2 is to say, look, we're not opening the courthouse door to every claim. There's a limited number of claims that we think this is going to apply to. And that makes me, the Chief Justice, comfortable enough for going forward for now. Because then, as you also noted, Justice Kavanaugh has some words that look a little different, right? Maybe I'm not comfortable with this for other reasons, but those reasons haven't been presented in this case today.
Amy or Rahul, any comments on that or elaboration?
Yeah, and I'll just say from a practical perspective, from kind of a litigation perspective, Section 2 cases are not easy to litigate, and the data bears that out. There are, we've marched through kind of the jingles preconditions, the Senate factors. There are a lot of facts, and there is a lot of evidence that you have to marshal in order to be successful on a Section 2 case, pre-Milligan and post-Milligan. So, from a practitioner's perspective, I think, we filed this case pre-Milligan. We were in a PI hearing when the Supreme Court stayed the Alabama decision pending a full review by the court. And I think most voting rights practitioners expected the standards to become more difficult. And I think everyone is heartened that Section 2, the framework of Section 2 was reaffirmed. 40 years of the way we've been litigating these cases was reaffirmed. But that doesn't mean that these cases are easy by any stretch of the imagination. There's a lot of evidence that you have to put forward, that you have to marshal in order to prove these cases. So no matter what, these Section 2 cases require a lot of analyses, whether you're looking at racially polarized voting or compactness scores. It's a very technical endeavor. And I think that will continue to be true no matter what, and especially if the Supreme Court goes back and tinkers with the standards later on, which, as Amy has noted, is not a remote possibility.
Amy, you were nodding your head as the comments were being made. Any thing you'd like to add to that?
I think the thing I would add is sort of, also more broadly as we think about issues in other areas of the country, right? Again, one of the things that is difficult here is that you do, in fact, need to show that there is racially polarized voting. And we do not see the same type of correlation between race and party identification and votes with a lot of other groups. So even as we see, for example, this occurs much more so on the West Coast, right? Really large increases, for example, in Asian American populations or in Hispanic populations. Certainly they're growing in Georgia, but much more so, right? If we're sort of looking at areas of the Southwest, et cetera. But what we don't see out of, right, of the people that even when they're living in the same areas, it's a much more heterogeneous population in terms of political identification, even if it's homogeneous in terms of sort of cultural, ethnic, racial identification. And so that means that also saying that you have this group where they're not getting to elect, right, who they would like to see elected is much harder to even show of where it is. So there are some that are coming. They're much more likely to happen. Actually, somebody, Kareem just noted, sorry, I saw it pop up in the chat, at when you look not at congressional level, but rather at the state legislator seats, because to Rahul's point, those are much smaller areas. So therefore you do start to see, and so that what that then means is that you start to see these questions going from being at the congressional level, because you have to prove sort of so much, down to these much smaller districts that we see in the state legislatures. And just to circle back to one really important point that Rahul made that I have a tendency to say to my students ad nauseum, the reality is most of the laws that affect each of us on a day-to-day basis aren't made at the federal level. They're made at the state level. Sometimes they're even made by the city government. And we completely ignore those elections. We completely ignore those legislative maps. But the truth is, who it is that represents you in the Georgia State House, which is not terribly far from where I am right now, is going to have much more of an impact on your daily life than who is representing you, honestly, up in DC. And so having that, right, looking at those maps is equally, if not more important as we have these discussions. And again, kind of recognizing what that means and what is a community of interest, right? How does that break down? What does it look like? What are those things that matter? And where is that going to take us to in the future?
Rahul, a quick question. If you win your state level cases, and get the additional seats that you're asking for, what is the political balance in the Senate and the House going to be under that assumption? Do you know the numbers?
I don't know the numbers off the top of my head. What I will say is we are litigating in the State House and State Senate that there should have been at least 6 additional opportunity districts that were drawn. So and this again is when you look at Southwest Georgia, the southern swath of Atlanta, the Augusta area. If you look at the state as a whole, that there should have been 6 additional districts between the State House and the State Senate.
Well, that's yeah.
Al, are we ready to move to a few questions from the?
Yeah. Thank you for your comments and so forth. Let's go to let the audience pose some questions. And Janet, I take it you're curating the questions?
Yes. People
right.
have been putting stuff in the chat. And if you have a burning question, we have limited time, but go ahead and put it in the chat. So I guess the first group of questions really go to you, Rahul. Folks that are, curious about if you're successful in the trial that starts on September the 5th, what are the likely remedies? What's the likely process and timeline, especially in relation to the 24 election?
Yeah. So like I said, timing came up when we brought a preliminary injunction motion back in February of 2022. We actually had our final pretrial conference with the court yesterday, and we talked a little bit about timing. The judge indicated that he was going to move as swiftly as possible. He's aware of the timing considerations. He's very aware because, we were in his courtroom a year and a half ago on this issue. So what he told us is that he expects to move as swiftly as possible following the conclusion of the trial and after we put in proposed findings of fact and conclusions of law. And that he does not expect to that timing will be an issue when it comes to the 2024 election. So we are hopeful that after we get through the liability phase, if we're successful at that juncture, then we'll quickly proceed into a remedial phase. The legislature will get the first crack at a remedial map, as was the case in Alabama. We hope that the Georgia legislature, if we are in that posture, does not have the same reticence to drawing maps that are consistent with the Voting Rights Act. But again, we're hopeful that this time around that we will have a resolution to this before we get to the 2024 primary, which happens in May of 2024.
With qualifying though in March.
That's right. That's right. So qualifying happens in March. So, you know, we would have to have those maps in place by March of 2024.
And one other related question, and that's related to the fact that there's the group of 3 cases that go here in September, and then there are 2 cases that go before 3 judge panels with, I guess, constitutional issues on November the 13th. So any thoughts in terms of, you know, conflict or coordination in terms of what may come out of those?
Yeah, I mean, those cases, I believe, go to trial in November before a 3-judge panel. And so depending on the timing of a potential order in the 3 Section 2 cases, that might have an effect on, you know, when those other 2 cases go to trial, how they want to proceed, if they want to wait for a remedial map. It's too early to say right now kind of how the cards will fall, because I think, you know, the judge in our case is focused on the 3 cases before him and before this court. And so that will be something that comes into play, but right now it's hard to tell how exactly it will come into play without knowing kind of the outcome of the first tranche of cases.
Yeah. I'm just looking at the time here and realizing we are out of time. There are lots of other questions and we could have kept you for a lot longer tonight. Al, some closing words?
Well, first of all, many thanks to you guys for being on the panel and giving us the insight of your brain trust knowledge. There is a lot more to talk about, and maybe we'll have an opportunity to elaborate a little bit, particularly after the hearings in Alabama and your upcoming hearing, Rahul, are concluded. And maybe we'll pester you one more time to help us out, but very helpful, and I appreciate the comments. Very astute. I appreciate it.
Thank you, and my thanks to Al for moderating, and to all the panel. We've got just a couple of things that we want to highlight to you before we leave. One of those is that if you are interested in the trial that we just talked about that starts on September the 5th, it's 3 of the 5 redistricting cases that have been filed here in Georgia go as a group to trial, and that will be at the federal courthouse in downtown Atlanta. And we want to be there. We want to have representation throughout the trial in order to see what's happening ourselves, and to really kind of help inform our work going forward. So we're recruiting an observer group to participate in this. And if you are interested, please go to this link, bit.ly FDGA Court Core, and sign up. And we'll be putting together a schedule so that we can cover the entire trial, be there with Rahul and watch him in action. And then lastly, just to let you know that we are planning a town hall in September. It is scheduled for September the 26th. And our focus of that town hall is going to be on mid-cycle redistricting. We have, as you know, been concerned about the use of mid-cycle redistricting in Georgia. And we're looking at bringing forward kind of all of the issues that we've seen with it and some possible solutions that we want to advocate for as we go into the next legislative session. So please mark your calendars, and we'll get that link out to register for that September 26th date. As always, you know that we're an all-volunteer organization, and we appreciate any donations. So if you have some capability to help support Fair Districts Georgia, please do that. And with that, we will say good night and thank you for joining us. And again, thank you to our wonderful panel.